the Orake family okay,
Sorry.
no, by some way, were you saying something?
Yeah, yeah.
I wasn't hearing.
I was apologizing for coming in late. I had issues with my Zoom application, but I'm here now. My sincere apologies. Can you hear me?
Yeah, good afternoon. I can hear you.
Okay. How you go, Chugu?
Yeah, good afternoon, Chief.
Good afternoon.
Yeah.
Okay, so, can I know you can hear me, but I was not hearing us before. Can someone talk? Let me know if this has been rectified.
Hello, Ruth. I can hear you loud and
Yes.
clear now. I don't know if you
Okay.
can hear me.
Yes, I can hear you now. Okay,
All
that's
right.
fine. I know you were saying something before now, but I couldn't hear you.
Nothing. I was just apologizing for coming late.
Oh, okay. Apology accepted. So I think it's remaining Barrister Mary. She's on her way, but I'm sure she'll be joining shortly. All right. Wait, I'm coming. I was at the point where I just wanted to do a recap of the mood facts. Just also as my way of um giving Mary a minute or two to join. Okay, so in 1954, the mood facts. In 1954, Orake family represented by their family head, Osake, gave a vast portion of their family land to Aku indefinitely. It was agreed that the land will be used strictly for the cultivation of palm trees. Aku offered Orake kola nuts before he took possession. In 1987, Orake invested in Aku's farming business. It was agreed that Orake will be entitled to 20% of the annual palm harvest for 10 years. After Aku's death in 1989, his son Agu took over the farm and gave Orake 20% of the annual harvest till 1998. In 1999, Orake demanded unpaid rent from 1955 since Aku only gave him kola nuts before taking possession. In 2022, Agu fell ill and had to travel abroad for treatment. He remained abroad for 3 years, during which time the farm fell into disrepair. In the meantime, Orake started harvesting and selling the palm nuts. And then in 2004, he leased a portion of the land to Akpan and cleared the palm trees in the leased portion to enable Akpan build a factory. Upon Agu's return in 2005, he entered into an alliance with Akpan to dispossess Orake family of the land. Agu contended that he inherited the land from Aku, who had been in possession of the land since 1954. Akpan also alleged that Orake was a land spectator and a thief. When Orake heard this, he said that Agu was a disgrace to his father's name, instituted an action to eject Akpan from the land, but left Agu on the land. In 2016, Agu cleared all the palm trees and set up a pure water factory on the land. Orake accused him of breaching the agreement reached with his father in 1954 on higher talks to eject Agu from the land. Agu, displeased with Orake's action, has approached you as his lawyer to file an action in court over the ownership and possession of the land. Okay, as we all are aware, Impel, Tim Ruby is the claimant, while Tim Pell is the defendant. All right, and just as I had already sent to your emails, you just have 10 minutes for examination in chief. I'm now talking to the teams. I would soon leave the floor for the judges and particularly the presiding judge. So I just want to say this before I get off your faces. The exam in chief is 10 minutes. Cross-exam is 10 minutes, and re-examination, if needed, is 5 minutes. Then the closing statement is 10 minutes. Please, teams, know that timing is part of what you're being evaluated on. So all the best. Justice Chimeze Onuzulike, you have the floor.
Justice indeed. Thank you very much, Ruth. Good afternoon to everyone. My name is Chimeze Onuzulike, and it's a pleasure to be here with you all today. So, of course, this is a competition, but it's also an opportunity for learning. All right, you are not just learning; we are also learning. We on this side, we are equally learning from you as well. I'm sure that there's a lot to learn from the entire process. All right, so it's your time now, Team Pearl and Team Ruby. Understand that Team Ruby is the claimant and Team Pearl is the defendant. So I would first of all take appearances from the parties before we proceed, please. Claimant, counsel.
May it please this honorable court, appearing before your lordship is my humble self, N.E. Ochojila, announcing appearance for the claimant. Your lordship, counsel is not alone. I'm appearing with my learned brother,
Would you please spell your name
M.H.
for me?
Zakaria, announcing appearance for the claimant.
Sorry, please spell your name. Okay, I can see your name. N.E. Ochojila, appearing with who?
M.H. Zakaria.
Okay. Appearing for the claimants.
Announcing appearance for the claimants, my lord.
All right, thank you very much. Defendant.
With utmost humility to this honorable court, I am H.B. Bolade. My lord, appearing with me is my learned friend, C.J. Chima. Our humble appearance is for the defendants.
All right, thank you very much, Mr. Ochojila and Ms. Bolade. Please, quickly, could you identify the processes that you filed in this matter before we proceed? The claimant, please, Mr. Ochojila.
Most obliged, my lord. Your lordship, before this honorable court is a writ of summons marked as suit number DHC/UGH/207/2024, dated and filed on the 20th day of August 2024. Your lordship, the process is in compliance with Order 3, Rule 1 and Rule 2 of the rules of this honorable court, and is accompanied by a statement of claim, the list of witnesses, the witness written statement on oath for the first, second, third, and fourth witnesses, as well as the list of documents to be relied upon during trial. Your Lordship, in the process before this honorable court, the claimant prays that this honorable court grants the following relief sought on page 7 and page 8 of the process before your Lordship. Counsel prays that this honorable court grants these prayers and the process be adopted.
Thank you, Mr. Ochojila. I just want you to identify all of the processes that you filed in this matter, all of the processes that you filed. All right. Okay, so let me help you. Let me help you, all right? You filed the writ of summons with the accompanying processes that you've just identified, all right? You filed a
counter affidavit. Accompanied with a written.
In reply to the defendant's notice of preliminary objection.
Yes, my lord.
Counter affidavit was sworn on the 26th day of April 2024.
Yes, my lord.
And then again, you filed a defense to counterclaim of the same date.
Yes, my lord.
Good. Those are the processes that you filed.
Yes, my lord.
All right, thank you very much. Ms. Bolade.
My lord, before the court today, we have notice of preliminary objection, which is dated 24th day of August 2024, as well as our statement of defense and counter, as well as statement of the counter claim dated 24th day of August 2024 as well as the accompanying documents for this case. Most obliged, my lord.
All right, thank you very much. I confirm that I have all your processes. Just needed to be sure that there are no processes that I have missed. So what's the business of the day?
Thank you, my lord. The matter today is slated for hearing. Subject to the riding convenience of this honorable court, we seek the claimant is ready to proceed.
All right, Ms. Bolade.
My lord, before the official opening of the hearing of this case, would like to put forth our motion for notice of preliminary objection. My lord, this motion is brought pursuant to Section 36 of the Constitution of Nigeria, as well as the rules of the Delta State High Court Civil Procedures Rules. My lord, this motion is brought on two grounds, that this honorable court lacks jurisdiction to hear this matter. That
Ms. Bolade,
sir?
You allow me grant you permission before you proceed to argue your motion.
As court uses, my lord, apologies.
You would seek the permission of the court to argue your application, and then before you can proceed. All right, that's how it's done in practice. Okay, but proceed. Of course, Mr. Oshojila, you filed a response to the application. So I would take the notice of preliminary objection. I will take arguments on the notice of preliminary objection before we proceed with trial. It's challenging the jurisdiction of this court.
As the court please.
Most obliged, my lord. My lord, the action or this matter before the court was brought or was filed. It was filed on the 3rd day of August 2024. However, my lord, if you take a look at page 2, page 3, and page 4 of the claimant's originating process, you find out that it is lacking the signature of not just the registrar, but the dates and address of which it was signed. My lord, it is tried law that a document which is not signed is a worthless document and has no abusable form in law. My lord, this lack of, in the case of Ohakim and Agbaso, Supreme Court take out determination of jurisdiction of the court. Supreme Court also mentioned that the writ of summon is a fundamental requirement in instituting an action against the defendant. Hence, it must be properly served on the defendant for the court to assume jurisdiction. Proper service of an originating process goes to the fundamental human right of fair hearing of defendants, guaranteed under Section 36 of the Constitution of the Federal Republic of Nigeria. My lord, in accordance with the Delta State High Court Civil Procedure Rules of 2009, Order 3, Rule 6, the writ of summon is to be prepared, signed, and issued by the registrar. My lord, it is tried law that an unsigned document is a worthless piece of paper, and such incomplete originating process is inchoate, legally non-existent, and cannot be saved by way of an amendment. My lord, also, the Court of Appeal has heard in Alhaji Abdul Karim Buhari and Alhaji Muhammad Adebayo, which is on the page 6 of our preliminary objection, that basically an unsigned or irregularly signed writ is worthless and incapable of hitting the ground running in legal proceeding. Being an initiating process, the statement of claim and all other processes that swerve on the helpless writ are correspondingly affected by the same virus and consequently is rendered incompetent, my lord. My lord, on these arguments stated above, it's, if you look at this writ of summons, like stated before, that was served on us by the plaintiff, it was discovered that this writ was not signed. And why in the counter affidavit, the claimant has gone ahead to state that it is the registrar who is at fault. However, this is just shifting blame. It doesn't change the fact that the document before the court is improper. My lord, it is the claimant's duty to prepare the originating process and ensure that all conditions precedent to the invocation of the court's jurisdictions are fulfilled. And having failed to do so, this suit has not been initiated following this process and in compliance with the condition precedents, the consequence of which is that the writ is therefore incompetent and incapable of properly invoking the jurisdiction of this court over the defendant and is therefore liable to be struck out for want of jurisdiction. My lord, it is, with all this, we make our humble submission that the action of the plaintiff be struck out as the court last jurisdiction to entertain the matter due to failure to obtain the registrar's signature on the writ of summon. And may it please the court.
Thank you very much, Ms. Bolade. Now, please, I want you to summarize your points for me, because I'll ask you some questions before Mr. Ochojila will proceed. All right? Summarize the key points on which you are asking this court to strike out the suit. The grounds, just the grounds. Okay. The grounds.
Whether service of an unsigned writ of summon renders the action irredeemably fatal that robs the courts of its jurisdiction. Sorry.
Okay. So the basis of your objection is solely on the grounds of failure to sign the writ of summons.
Yes, my lord.
So I want to ask, whose responsibility is it to sign the writ of summons? Is it that of the claimant or that of the registrar?
My lord, it is a shared responsibility.
I don't understand that. Is it that of the claimant or that of the registrar?
My lord, the registrar's duty to sign it, but it does not negate the claimant's duty to ensure that the proper processes are filed before service on the defendant.
Okay. Mr. Ochojila, your response.
Thank you, my lord. Your Lordship, in response to the notice of plenary objection filed by the learned counsel to the defendant, the claimant filed a counter affidavit and a written address accompanying it, and counsel seeks the leave of this honorable court and praise this honorable court that the written submissions in the written address be adopted as the oral submission of counsel. However, counsel seeks leave of this honorable court to adumbrate on key and salient issues as the court pleases.
Please proceed.
Your Lordship, in the written address, counsel rose two issues of determination. One, whether the failure of a registrar to sign a writ of summons makes the writ of summons effective. In bid not to waste the time of this honorable court, the court has severally heard that the court will never punish a litigant or the counsel for the sins of the registry or the registrar. And the counsel provided a litany of cases in the written address to support this position. Your Lordship, the counsel to use his due diligence, filed the process, prepared the processes and filed it before the registry and paid the appropriate and required dues and filing fees as in compliance with the rules of this honorable court. The responsibility to sign the writ of summons and serve the defendant lies solely on the registrar. The court, your Lordship, we appreciate the industry of the counsel of the defendant, but this is trying to strike out a substantive suit and to do away with substantial justice on the basis of technicality. And like the former learned Chief Justice of Nigeria, Walter Onogen, said in the case stated in the written address, that the days where technical justice reigns is over. And now sitting on the throne is substantial justice. Your Lordship, substantial justice will not be done if a case will be struck out because the registrar failed to sign a writ of summons that was duly prepared and served on the defendant in the time stipulated by the law. Secondly, your Lordship, as to the second issue, we want to draw the attention of this honorable court to the fact that even the notice of preliminary objection is defective based on the ground that the affidavit in support of the notice of preliminary objection was signed and deposed to by the counsel who filed and signed all the processes on behalf of the defendant. And the court has held severally, and even the rules of professional conduct has prohibited lawyers from signing and deposing to affidavits in matters that they are handling. Your Lordship, it's on this basis that counsel prays that the court oppose the submission of the defendant. One, that the failure of the registrar to sign a writ of summons is not defective and does not rob this honorable court of jurisdiction. And two, that the affidavit in support of the writ of summons is defective and thus has no standing before this honorable court. I so humbly submit.
All right. Thank you very much, Mr. Ochojila. So I understand that the issue here is whether the registrar's failure to sign the writ of summons renders the writ incompetent. So, Mr. Ochojila, I want to ask now, did you sign the writ of summons?
Yes, my lord. The writ of summons and all the accompanying documents were duly signed. The only portion that was not signed was that was to be signed by the registrar.
You signed the writ of summons?
The accompanying document.
Did you sign the writ of summons itself?
No, your lordship.
You signed the statement of claim and other accompanying documents?
Yes, your lordship.
Okay, now, so before I even determine the main issues, I want parties to address me on the effect of failure of counsel to sign the writ of summons or the originating process. Failure of counsel to sign the writ of summons. I want parties to address me on that point. Ms. Bolade,
My lord,
yes, you have addressed me on the effect of failure of the registrar to sign the writ of summons. Now, I am now raising this issue SWOMO to failure of counsel to sign the writ of summons. I want you to address me on what is the effect of that failure.
my lord, it is the position of the law, and it is well settled that for a document to be admissible, the document must be signed, as an unsigned document cannot be admissible in law, and it has no probative value. This was the position of the Court of Appeal in Guma and Sadani and others, 2019, Wright and others, and Iwocha. My lord, the Supreme Court and the court generally has heard in a plethora of cases that signature evidences, it gives legitimacy and authenticity to a document. One cannot dish out a document and state to be behind it. Just like the affidavit on which my learned friend is currently deposing to, he has also failed to obtain the signature of the Commissioner for Oaths. But he also claimed that should it be blamed on the commissioner on the basis that it is unsigned. However, in the case of Bello and MBA, the Court of Appeal clarified the position of the law and held that it is the provisions of the Section 97 of the Sheriff and Civil Process Act that a service of a writ without proper endorsements, as stipulated under Section 97, is not a mere irregularity, but a fundamental defect that renders the writ incompetent. As in this case, not just the registrar, but the counsel himself has failed to sign it. What we just have is just his words against a document which operates on the doctrine of res ipsa locutor. The document speaks for itself. So on this basis, we urge and plead with this honorable court to discountenance the argument of Melanie Kone and enter judgment for defendants. May it please the court.
Thank you very much. Mr. Ochojila.
Your Lordship, the court, going by the rules of this honorable court, the writ of summons is to be signed by the registrar. We would like to put that on record that the portions that counsel should sign were duly signed by counsel. I also want to avert the mind of this honorable court respectively to the fact that this is a virtual competition, and then there was no way the portion for the commissioner of oath would have been stamped as we were typing it to be served on them. Notwithstanding, the position of the law is that even where counsel fails to sign, the court has held severally that the litigant will not be punished for the sins of the counsel.
All right. Thank you very much. You've both explained to me the position of the law as you both understand it to be. All right. The defendant's notice of preliminary objection is premised on the ground that the registrar did not sign the writ of summons, and that failure renders the writ of summons incompetent and liable to be struck out. Now, I had to raise the issue SWOMO as to whether the failure of the counsel himself to sign the writ of summons renders the writ incompetent. And I've taken an address from both counsel, because I note that the writ of summons was also not signed by the claimant's counsel. All right, so the position is that the writ of summons must be signed by counsel to the claimant as the originator of that document to give it any validity in law. It has to be signed by claimant's counsel. The registrar endorses on the writ of summons to receive the writ. All right. So the signature of claimant's counsel is very, very important. It's indeed it's what gives the writ itself that validity. All right. Now, the position of the law is that the failure of the counsel to sign a writ of summons renders the writ of summons incurably defective. It means that the defects cannot be cured since it's an originating process. The counsel needs to sign. Failure to sign the writ renders it null and void. That's the position of the law. Again, with respect to the defendant's preliminary objection on the registrar's failure to sign the writ or endorse the writ of summons, the position of the law is that the sins of the registry will not be visited on the party. All right. So the failure of the registrar to sign the writ of summons does not render the writ incurably defective. All right. It's an error that can be remedied. All right. It's not a fundamental error. So on that premise, the notice of preliminary objection cannot succeed. All right. That's just a procedural error that can be remedied. But on the issue that I have raised suo motu, what it means is that this writ by which this suit was commenced is incompetent because it was not signed by counsel. All right. I will also proceed to consider some of the points raised by Mr. Ochojila with respect to the validity of the preliminary objection itself. Mr. Ochojila had said that the affidavit in response to the notice of preliminary objection is defective, all right, because it was signed by counsel to the defendant. And he cited Akinlade against INEC, where HJIUF said that counsel should not sign or act as a witness for the client. If he does so, whatever evidence he gives would be discountenanced. All right. I just need to mention first that this is an objection. The notice of preliminary objection is an objection on jurisdiction. It's not even compulsory that it should be accompanied by an affidavit. It can be filed, can just be a notice of preliminary objection and a written address. So even if the court decides to say, I will not consider the affidavit because it was deposed to by counsel, and then the court proceeds to discountenance the affidavit, it does not render the preliminary objection incompetent, because in the first place, it's not necessary to file an affidavit in support of an application that is based on jurisdiction. All right, it is law, it's not based on facts. It is when you are seeking for a relief from the courts that require the court to rely essentially on facts. That is when an affidavit would be necessary. But in this case, an affidavit is not even necessary in the first place. So that argument cannot be sustained. And even on that point, I just need to mention that the position of HJIUF in Akinlande and INEC is a bit controversial. All right. Of course, a more recent decision, Moot and PDP, that's 2023 7 Nigeria Weekly Law Reports, parts 1883, page 357. Even the Supreme Court in that case alluded to the fact that the ROPC does not render evidence deposed to by a lawyer on behalf of his client inadmissible. All right. They only render such lawyer liable to for professional misconduct. At any rate, that like I said, the objection touches on jurisdiction. So even if we decide to say the affidavit is incompetent, the objection will still succeed. All right. So the point is that even if, of course, Akinlade and INEC is a decision of the Supreme Court, that point is still quite controversial as to whether failure to depose, the lawyer deposing to an affidavit on behalf of the client would render that testimony inadmissible is still a very controversial position. The truth of the matter is that is not a rule that guides. It's not a rule of evidence. All right, so it does not govern admissibility. What governs admissibility is the Evidence Act, and if a document or an evidence is admissible under the Evidence Act, the RPC cannot exclude the admissibility of that evidence. Because the ROPC applies only to the lawyer and not the evidence of the lawyer who deposes for the coup would be to now elevate the governing evidence. All right. So, like I said, even the Supreme Court alluded to the fact that the ROPC, what governs the Evidence Act, all right, not the upon it that was published in the Gravitas actually read upon it. All right. So on the main point as to whether the writ is competent, since it was not signed by counsel, ordinary months and the entire suit. But for the purpose of this competition, would allow
Okay, Justice Mezie, we are having issues hearing you. I don't know if I'm the only one.
so
We've stopped hearing you. We've stopped hearing you. Oh. Where is this? What is this? What is this?
sorry, I don't know. I was disconnected. I thought there was something with my internet. I don't know.
Okay, yeah, we stopped hearing you. I was trying to
Okay,
tell you.
I was seeking the contribution of my co-judges.
Okay, Justice Oge, Justice Ugo, Justice Eli. The floor is open for the judges. Any of the judges' contribution on this preliminary objection subject matter.
I thank you. Can you hear me?
Yes, we can hear you.
Okay, I align myself with the thoughts of with the position of the presiding judge. If I was going to add, I'll just say, there is the writ of summons, and then there's the part for the endorsement on the writ. So there are indeed two columns for a signature. So the writ column in itself is before the NP, and there's a case law that has tried to even differentiate between the writ of summons from the endorsement on the writ. It's quite funny. But then the Supreme Court case again in Main Street versus R Incorporation. So the point is, indeed, it is for the registrar to sign on the first column where you see there's a dash that has the registrar just underneath it. And then after you have the address for service, after the note below, you see a part where you will put the address, your name, and then perhaps the law firm and your phone number. And then you're supposed to sign at that particular point. So if council has not done that, then that's still a problem. If there's no signature on that part, because it will be so hard to use the argument that the registrar did not sign. Okay, fine. It should not be visited on council. But then did you sign on the column where you're also supposed to sign to show that it emanated from you as the claimant, as the counsel for the claimant? If that is not done, then that document now becomes, the fate of it now becomes that it's still a worthless document, to the extent that you did not sign on the part where you're supposed to sign. But then it now goes back to the point again on, because there's actually a Supreme Court case again, that says that where you do not sign, that it is duty of the council to sign, the writ, as the president has also said. But then we also know that where the registrar fails to do what's supposed to do, the sin of the council should not be visited on the litigant. The sin of the registrar should not be visited on the litigant. So if those very fine lines. Then on the issue of the counter affidavit too, indeed, the Nithya versus PDP's position as like it has offered, some sort of leeway, because indeed, one would have said that the decisions, the Akinlade and INEC and APC and PDP, which coming from the same justice anyway, was a bit, controversial, a lot controversial, really. Right, but now things have been modified now to read. From the language of in Nithya PDP, one can see now that indeed it is the place of the Evidence Act to determine the issue of admissibility, and since it has not been said that where a counsel deposits to an affidavit and it suffers such fate, then in the Evidence Act, then why should the RPC not be the one to? In fact, the RPC did not even say that anyway. So I think I align myself with the position of the presiding judge. It's also very interesting the sole motive issue that he also had to raise. So at least that's supposed to like test, the knowledge of the counsel that we have, before us today. So that's my 2 cents on the issue. Thank you.
Thank you very much, Ogoja. Okay, so if we don't have any other contribution, I think we'll just proceed to hearing. Mr. Ochojila.
Thank you, Your Lordship.
Yes, how many witnesses do you have?
Counsel, the claimant counsel has 4 witnesses.
Okay.
And
You know the rules. You know the rules, all right? I need to understand from the coordinator, because I understand that you have 10 minutes for examination in chief. So I need Ruth to advise us if 10 minutes means that you will have 10 minutes for each of your witnesses, or you have 10 minutes for all of the witnesses. I need to understand. Or if we're just going to call one of the witnesses, I don't know if there's any need for us to call 4 witnesses in this case.
The ball is in your court, but I think they can just leave it at 2 at most to save time.
Okay, why I ask is, if you're calling 2 witnesses, it means the other party will probably have time to cross-examine as well. All right, so it means you now have 20 minutes examination in chief and 20 minutes cross-examination. Okay, Mr. Ochojila, do you want to call 2 witnesses?
Your Lordship, if the court is being benevolent to give us 20 minutes, we can take the 4 witnesses in chief. We can lead the 4 witnesses in chief in that 20 minutes or less. Since it's a civil matter, their statement or notice ready before the court.
Maybe we could reduce the time.
Yes, what we're going to do, my suggestion is, since you are going to call 4 witnesses, and we'll give you 20 minutes, you have 5 minutes for each of the witnesses. All right. And then the defendant will equally have 5 minutes to cross-examine each of the witnesses.
As the
I
court
don't know
pleases.
if, yes, I don't know if I'm speaking the minds of other of my co-judges. All right.
Okay, Ugo, Eli. Okay, Ugochukwu has responded that he aligns with that.
Okay, so that's fine. So proceed, please.
Most of your Lordship. Your Lordship, counsel at this point seek that proceedings be deferred to my learned brother, M.H. Zakaria, who would lead the 4 witnesses in chief. We have CW1, CW2, CW3, and CW4 all present in court.
All right. Thank you. Please proceed.
Respectfully, my lord. Hello, can you hear me?
Can hear you loud and clear.
All right. I am M.H. Zakaria, co-counsel for the claimant in the matter before this honorable court, Your Lordship. Your Lordship, this matter is slated for hearing, and counsel is ready to proceed, subject to the overriding convenience of my noble lord.
Please proceed.
Thank you very much. My lord, I will call on our first witness, CW1, Mr. Abu David. Witness, can you hear me?
Yes, I can hear you.
All right, please, can you tell this honorable court your name, your occupation, and where you reside?
Okay, good afternoon. I am Mr. Agu David. I am a farmer and a Nigerian citizen, and I reside at Road 2, Ifang Layout, Naraguta District, Ugeli North, local government area of Delta State.
Okay, very well. Quickly, witness, do you remember coming to the registry of this court to, depose to a written statement on oath?
Yes, sir. On the 20th day of August, I came and gave my witness statement on oath before the court registry in regard to the matter before this court.
Okay, so if you see the said statement, will you be able to recognize it?
Of course, I'll be able to recognize it by my name, the content, and my signature.
Okay, very well. My lord, at this point, I applied that the witness be shown be shown the written statement on oath to verify, my lord.
All right, registrar will do that, but let's take it that he has it in front of him.
All right,
It is
much
the
obliged.
it is
So
the
can you
witness
confirm?
statement that I signed. It is the correct
Okay.
witness statement on oath that I signed before the registry.
Okay, so what do you want this honorable court to, do with the written statement on oath with respect to the issue before the court?
I will want the court to adopt it as my oral testimony in regards to what I know about this matter. And I will also want the court to declare that I still have subsisting possessory rights over the land, and I have the right to peaceful enjoyment of the land without any encumbrance. And I would also like the courts to declare damages as I have suffered loss due to the actions of the defendants.
Okay. So witness, do you have any other thing you wish to, tell this court with respect to the matter before this honorable court?
Well, I think the only thing I have to add is that the said land in dispute was a land I inherited from my father after his unfortunate demise in 1989. I inherited the possessory rights over the land. And I would also like to say that my father, before he died, on his dying bed, made it clear to me that the defendant and his family offered him this said land. And the said agreement was ratified in front of the district head, Chief Kalu Ugochukwu. He also made me aware that before he took possession of the land, he gave kola nuts to the Orake family as tributes, as was customary in our tradition. And it was agreed that the land was to be cultivated for palm trees, and my family was to hold the land in perpetuity. He also told me that in 1987, and my family was entitled to give them 20% of the harvest for a period of 10 years. I also like to restate that sometime in 2002, I fell ill and I traveled abroad for medical treatment. And I did not return for 3 years as I was diagnosed with metastatic cancer and I needed to undergo extensive treatment. And that while I was away, it was to my greatest dismay, and I was shocked when I got informed by the district head that the defendant had started harvesting and selling the palm nuts on the land where I was customary tenant on. And upon my return in 2005, I discovered that the defendant had leased part of the land that was mine, that was in my possession, to one Mr. Akpan, who, when I came back, I found out that he was running a factory on the land in dispute. And so I confronted Mr. Akpan on how he came to be with the land, and he informed me that the defendant leased the land to him and gave him explicit consent to run a factory on the land. And in 2016, I got informed by the defendant of his...
Mr. Zakaria, your time is up.
Much obliged, your lordship. All right. That will be all for our first witness, my lord.
So, Ms. Bolade, cross-examination.
Most obliged, my lord. My lord, we seek this court's permission to go ahead with cross-examination of the first witness for the claimant. May it please this honorable court.
Please proceed.
Witness, how old are you? Do you mind telling this court how old you are?
I do not know exactly my age, but I am somewhere in my 50s from my estimation.
Okay. Witness, you mentioned that your father told you the details of the land on his dying bed. Is that correct?
Yes.
You also deposed in your witness deposition on oath that he came into possession in 1989. Is that correct?
Yes.
You also mentioned that your father got possession of the land in 1954. Is that correct?
Yes.
Witness, can you fully, confidently say you are aware of all the facts in this case?
To the best of my knowledge, I know of what my father told me as his dying declaration when he was dying about the said land in dispute.
Witness, where did you swear your written disposition on oath?
I saw it at the High Court Registry
Who
in
else was
Ugeli,
there?
Delta State.
Who else was there with you?
I went there and I signed it before the Commissioner of Oaths.
Did the Commissioner of Oath sign it?
Well, I am not aware of that.
Okay. Witness, you mentioned in your written deposition on oaths, you made a mention of the witness to Chief Kalu from time to time. Who is he?
He's the district head of our community.
How long have you known him?
Well, as the district head, I have known him during my stay, as I have lived for a while in the area where he's district head. So I've known him for a relatively long time, even though I cannot state with exactitude a number of years.
Witness, was Chief Kalu a party to the contract between your father and the defendant?
He was not
Yes.
a party.
Yes or no?
He was not a party, as the agreement is, as
That's
usual, is
all for
always
this
between two people.
Thank you very much. Mr. Ochojila, any re-examination?
There will be no examination, Your Lordship.
No, my lord.
All right. The witness is discharged. Can you call your second witness?
All right. My lord, witness, can you hear me? CW2.
Yes, counsel, I can hear you. Can you hear me?
Yes, I can hear you very well. So please quickly, can you tell this court your name?
Okay. I am Chief Kalu Ugochukwu.
Very well. Please, what is your occupation?
Well, I am the district head of Raguta district.
Very well.
Ughelli North local government, Delta State.
Where do you reside?
Beside River Naraguta district, plot 01, Naraguta district, Ughelli North local government, Delta State.
Okay. So, witness, you remember, deposing to a written statement on oath before the registrar?
Yes, I remember giving my witness statement at the court registry on the 20th of August, 2024.
Okay, so you written statement on oath if shown?
Yes, I would be able to identify the statement.
Very well. My lord, at this point, apply that the witness been shown the written statement on oath.
Yes, it has my name and my signature. It is mine. It is the written statement.
Okay, so quickly, what do you want this honorable court to do with your written statement on oath with respect to the issue before the courts?
I want the court to adopt the written statement on oath as my oral argument.
Very well. Do you have any Other thing you wish to ask this court to respect to the issue?
Well, I just want to state that kola nuts are used as tributes in any agreements made in our culture. Wherever two persons or two parties have an agreement, they give kola nuts to make sure that the agreement is binding. It serves as a tribute giving. And also, because I was present at the time this agreement was being made, there was no mention of any rent being paid or to be paid. So there was no mention of rent, just the tribute, the kola nut as tribute was enough and made the agreement binding on both parties, according to our tradition.
All right.
Thank you.
Very well, witness. My lord, that will be all for the witness with respect to testimony.
Thank you very much, Mr. Zakaria. Any cross-examination?
Yes, my lord. We humbly apply to cross-examine the witness, second witness.
Okay, please proceed.
Witness, do you eat kola nuts?
Do I eat kola nuts? Is that your question?
Yes, witness.
Yes, I eat kola nuts.
So that if I give you a kola nut, you automatically give me possession of your land? Yes or no?
Well, I'm not sure what you mean if you give me kola nuts. In what context, counsel?
Witness, you mentioned that kola nut was paid as tribute. So if I give you kola nut, does it mean you give me possession of your lands?
Well, if we have an agreement and you give me kola nuts, then it is deemed. Sorry, I did not get you, counsel.
Or no, witness?
I said I cannot hear you.
Yes or no, witness?
I said I did not get what you said. I did not get what you said.
Yes or no?
If you give me kola nut when we've had an agreement, yes, I would give you the land or honor the agreement.
In meeting held. Where do you say the meeting was held?
They had the agreement in my house.
In your house.
Yes, counsel.
Why was the meeting held at your house?
Well, according to tradition, when agreement of that nature is made, they come and they notify me as the district head so that I am aware of such agreement.
Witness, I put it to you that you are not a witness of truth. My lord, that will be all for this witness.
All right, thank you very much. Any re-examination?
No, my lord.
All right, thank you. Witness, you are discharged. Please, Mr. Zakaria, can you call your third witness?
Most of blood, your lordship. CW3, witness, can you hear me? Witness, can you hear me? Witness, can you hear me?
Yes, I can hear you.
Okay, very well. Please, can you
I can
tell
hear
this
you.
court your... Yes, I said, can you tell this honorable court your name?
I can hear you.
So can you tell this honorable court your name, witness? Witness, can you hear me? My lord, I seek the leave of this court to call on the next witness shortly before the CW to rectify the networking.
Okay, please call your fourth witness.
Much obliged, your lordship. CW4, if you can hear me, please.
Yes, I can hear you.
Okay, please, can you tell this honorable court your name?
My name is Okowa Orake.
Very well. Where do you reside?
I reside at Orake Family Compound, plot 356, Batili Way, Naraguta District, Ugeli North, Delta State.
Okay, so what do you do for living?
I am a farmer.
Okay. Because do you remember the written statement of this court?
Yes, I do remember doing that.
Okay, if shown, you'll be able to identify the written statement on oath.
Yes, I can remember. I can notify that with by my signature and by my name.
All right. Please, can you confirm to the court if the document before you is the one you sign? That's your name there?
Yes, that's my name and also my signature.
Okay. So what do you want this court to do with your written statement on oath with respect to the suit before the court?
I would love this honorable court to adopt my written statement on oath.
Okay, very well. So do you have any other thing you want to tell this honorable court with respect to the matter before this court?
Yes, I would want to bring it to the notice of this honorable court that Osake Orake, the defendant, is my brother, and that at the time 1954, when Mr. Aku, now deceased, came to seek land from us, there was no agreement for rent, and also he brought tributes to us, kola nut, as is our custom, after we went to the chief's house for the agreements, and I was there during the entire agreements.
Oh, okay. My lord, the witness has the written statement on oath has been adopted, and that will be all for CW4, Your Lordship.
All right. Thank you very much. The witness is discharged. Is your third witness ready
My
now?
lord, cross-examination.
Oh, I'm very sorry. I'm very, very sorry. Please, Ms. Bolade. Uh, I guess I'm in a hurry to get on to the next one. So please, cross-examination.
Thank you, my lord. Witness, you mentioned in your paragraph 2 of your written deposition that you are a member of the family and the younger brother of Mr. Osake Orake, who is the defendant. Is that correct?
Yes, that's true.
So you acknowledge that Mr. Osake is the family head?
He is our representative.
He's a representative?
Yes.
Capacity?
You said?
In what capacity?
He is our representative. He is the one that represents us in.
Yes, sure, my lord. The witness already answered the question being asked by my learned counsel. I see no reason why.
No, sure. The witness has not answered the question. The counsel asked two questions. The first question was whether he asked the witness if Mr. Orake is the family head. The witness said he represents them. And she asked another question, in what capacity? There are two different questions, all right? So allow the witness answer the question.
Please use the court, man.
As God pleases. Witness, in what capacity does Mr. Osake represent the Orake family?
He represents the Orake family, our family, as our elder brother.
Am I to presume from your written deposition that you are not a principal member of the family?
I am, as a male child.
Your brother is the family head. How are you the principal member of the family?
I am part and parcel of the family. And so I am also a member of the family, and I can always represent him where he's incapable.
Witness, do you have any proof, probably a power of attorney, to show these claims they're saying you're insisting on?
These claims, please come again. I don't understand your question.
Witness, I put it to you that you are not aware at all of the facts that took place between Mr. Ako and Mr. Osake. That'll be all for this witness.
Because Mr. Ako came to us and we went to the chief's house for the agreements of customary tenancy.
All for this witness.
They did not ask you any further question. They only put it to you. All right. Okay. So any re-examination?
Your Lordship, just one question.
Sorry.
I don't know if I can be heard, Your Lordship.
Are you taking over from Mr. Zakaria? Let him inform the court that he wishes to hand over to you.
As the court pleases.
Can you hear me, Your Lordship?
Can hear you.
All right. I defer proceedings to my lead counsel to address this honorable court on the issue he wants to clarify.
All right, please, Mr. Ochojila.
Thank you very much, Your Lordship. I want to just take one question for re-examination because of the ambiguity caused by the last question of the defendant's counsel.
Okay.
Witness.
Yes, counsel.
What do you mean by you are a principal member of the family?
I am also a member.
Hold on. Did the witness mention that he is a principal member of the family?
Yes, my lord.
No, my lord.
No.
Your Lordship.
No, I did not hear that. So please, unless you're saying I'm wrong, please, my co-judges, did you hear the witness mention that he's a principal member of the family?
No, I didn't.
Your Lordship, the counsel asked
Hold on. Somebody is speaking. I'm asking my learned brothers.
Yeah, my little brother, I think I heard from the question asked him, he said that he was a principal, he was part and parcel, of the family, and he can represent, but he did not say that he's
Exactly. Thank you. I heard that as well. So I didn't hear the terminology principal members, which is why I'm asking Mr. Ochojila where he got that from.
Your Lordship, it was the defendant's counsel that opened the door as to his.
No. No, do you want to rephrase your question? Because I didn't hear principal. So
Most guided, Your Lordship. What do you mean when you said you can represent your elder brother?
Well, counsel, you are aware that we are all humans and we are not entirely perfect. And so where my elder brother is incapable of representing us, I can always go there since I am a member and a legitimate son of the family.
Thank you, witness. Your Lordship, that will be all. Counsel seeks leave of this honorable court that proceedings be deferred back to my learned brother, M.H. Zakaria.
All right. Thank you very much. Mr. Zakaria, do you have any further questions? Re-examination.
No, my lord, in absence of our last witness, we're supposed to testify. We seek to stop at this point, and I therefore defer proceedings to my lead counsel.
So what you mean is that you're no longer calling your last witness?
Yes, Your Lordship, due to the network glitches having.
Okay, all right, so that's fine.
Thank you.
So, Mr. Ochojila.
Okay, Your Lordship, counsel would like to apologize for the act of the witness. He's having a lot of network issues and would not want to waste the precious time of this honorable court. So at this point, claimant counsel would like to close the case and give turn to the defendant's counsel to open their matter. The court please.
All right, thank you. The witness is discharged. Ms. Bolade.
Most obliged, my lord. My lord, I humbly apply to transfer proceedings to my learned friend, HJIUF, to go ahead with the examination, my lord, if it pleases the court.
Please proceed.
Most obliged, my lord. I am HJIUF, co-counsel for the defendant in this case, my lord. My lord, I seek your indulgence to call my witness, number one witness in this case.
Okay,
Witness,
please
please
call
call the witness box.
I'm here.
Your time is counting.
Witness, please take this honorable court your name, address, and occupation.
My name is Mr. Osaki Orake. I'm a businessman, and I live at plot 356 Battery Way, Naraguta District, Ughelli North, Delta State.
On the 24th day of August, you made a written deposition on oath in this court. Is that correct?
Yes.
If you see this written deposition, will you be able to recognize it?
Yes.
What do you want this honorable court to do with this written deposition?
I want this court to adopt it as part of my evidence in this case.
Witness, in paragraph 11 of your written deposition on oath, you refer to a demand notice of an unpaid rent, which you gave to the claimant in 1999, and the one you gave to the claimant's father in 1957 and in 1960. Is that correct?
Yes.
If you see these notices, will you be able to recognize them?
Yes, I will.
My lord, we seek to tender this exhibit as part of our evidence in this case.
All right, so we take it that the exhibits have been shown to the will be showed or is now being showed to the claimant's counsel, Mr. Ochojila.
Most obliged, my lord.
Mr.
Witness.
Ochojila would have to respond, Ms. Chima.
Okay, my lord.
Mr. Ochojila, are you there?
Your Lordship, counsel has no objection to the document. They said later that
All right.
the defendant seeks to tender.
Okay, no objection. So the man notices dated April 12, 1957, July 19, 1960, and March 24, 1962, admitted in evidence and marked exhibits A, B, and C, respectively.
As the court pleases. Most obliged, my lord. Witness, in paragraph 12 of your written deposition on oath, You refer to a letter of abandonment dated 2003 you wrote to the claimant, informing him how he has left the palm tree plantation unattended to. Is that correct?
Yes, it is.
If you see this letter, will you be able to recognize it?
Yes.
My lord, we seek to tender this letter as part of exhibit in this case.
So we'll take it that the letter is now being showed to Mr. Ochojila, claimant's counsel. Mr. Ochojila.
Your Lordship, it's no more an objection,
You
just a notification that the said letter has
are
not been identified by the witness. Your Lordship, I can't get you properly.
Oh, sorry, I can't just me. I think my network is poor now. Can you hear
Okay,
me
I can
now?
hear you now, Your Lordship. Very well.
Okay, please proceed. Yes, you were saying something. I lost you for a few moments.
Your Lordship, I said the said letter has not been identified by the witness, so we don't even know if he has assented to the fact that he is the author of that letter.
The witness confirmed that when he was asked whether he referred to a letter in paragraph 12, then he
But he was not able
confirmed.
to identify the letter before this honorable court.
Okay, so what other form of identification? So this is not a fiscal hearing. So we take it that he has identified when he confirmed that he referred to that letter. So
Most
I
guided, Your
mean,
Lordship.
do you want him to identify?
Most guided, Your Lordship. Most guided. We are taking
You
the
want him to say I identify?
council has
All
taken
right.
the hint of the honorable court.
Okay. All right. So you are not objecting.
No objection.
Okay. Letter of abandonment sent in 2003 together with the certificate of compliance in line with section 84 of the Evidence Act is hereby admitted in evidence and marked Exhibit D.
As the court pleases, most obliged, my lord. Witness, in the same paragraph 12, you made mention that you took a picture of the said land when it was abandoned, as well as certificate of compliance in line with section 84 of the Evidence Act. Is that correct?
Yes, it is.
If you see this photograph and certificate, will you be able to recognize them?
Yes.
My lord, we seek to tender this exhibit as part of our evidence in this case.
So, witness, have you identified the photograph? Have you seen it? Can you identify it?
Yes, my lord.
Okay. So, we take it that the witness has identified the photograph. Mr. Ochojila.
No objection, Your Lordship.
All right. Photograph of the said land in dispute in its abandoned state and certificate of compliance in line with section 84 of the Evidence Act, about hereby admitted in evidence as Exhibit E.
As the court pleases, most obliged, my lord. Witness, in paragraph 17 of your written deposition on oath, you made mention of quit notice you gave to the claimant to vacate the land in dispute dated 2016. Is that correct?
Yes.
If you see this notice to quit, will you be able to recognize it?
Yes, I will.
My lord, we seek to tender this exhibit as part of our evidence in this case.
So take it that the witness has identified the quit notice. Mr. Ochojila,
No objection.
you have any objection?
No objection.
All right.
Witness,
Quit notice dated All right. Yes. We notice the dead match.
As the court pleases.
No,
Hello, sir, we can't get you.
dead match dead in 2016, hereby dead in evidence and marked exhibit.
As the court pleases. Most obliged, my lord.
Yes, can you hear me
Witness.
now?
Yes, we can hear you, sir. Thank you, my lord. Witness. Position on oath. You made mention
Yes,
of
please
owner's
proceed.
intention to recover possession when you gave which you gave to the claimant through your lawyer. Is that correct?
Yes.
If you see it, will you be able to recognize it?
Yes.
My lord, we seek to tender this exhibit as part of our evidence in this case.
Can you hear me?
We cannot get you well, sir.
Yeah, I apologize. My network is acting up. I don't know. Don't know why. Please, can you hear me now?
We can hear you, sir.
You can
Yes,
hear me
sir.
now? Okay. I apologize. My network is just really unstable. So I will take it that the witness has identified that document. Mr. Ochojila, do you have any objection?
No objection, your lord.
All right. Notice of owner's intention to recover possession dated 16 September 2017 is submitted in evidence and marked exhibit G.
As the court pleases. My lord, that will be all for this witness. I humbly apply
All
to
right.
this witness, my lord.
All right. Thank you very much, Mr. Ochojila. Any cross-examination?
Yes, your lordship.
Yes, your lordship.
Witness, welcome to court.
Go ahead.
Can you hear me, witness?
Yes, I can. All right.
You just testified before this honorable court. Please, I don't know if counsel can mute so that there will not be feedback. Thank you. Witness, can you hear me? I can't hear you, witness.
Yes, I can. Yes.
Okay. You just testified that in accordance with paragraph 11 of your written statement on oath, you sent in 1957, you sent a letter to the claimant's father, and subsequently you sent a letter to the claimant. Is that still your testimony?
So I didn't hear the ended part clearly.
You just testified that in 1957 you sent a letter to the claimant's father, and in 1999 you sent a letter to the claimant himself. Is that your testimony?
Yes.
Witness, are you telling this honorable court the truth?
Yes, I'm telling the truth, nothing but the truth.
Let me read the said paragraph 11 of your written statement on oath to you. With the leave of this honorable court, counsel seeks that since we are not physical for the witness to read the statement himself, we seek that. I pray this honorable court gives counsel leave to read that paragraph. Your Lordship, can you hear me? Your Lordship. Sorry, I can't hear you, my lord.
Please proceed.
Okay. It reads that sometime in 1957, 1960, and 1999, I sent a notice to the claimant demanding the unpaid rent from 1955, since Mr. Aku did not in
Yes,
any
please
way
proceed.
give us any tribute nor rent. So witness.
I can hear you.
Witness,
Proceed.
Witness, can you hear
My
me?
network.
Yes, I can.
So are you still standing by your testimony that in 1957 you sent a letter to the claimant's father?
Yes.
I put it to you that you have just lied before this honorable court, as your oral testimony is contradictory to the written statement on oath, which has just been adopted before this honorable court. Witness, can you hear me, witness?
Yes, go ahead.
Will I be correct to say that you know the land in dispute very well?
Yes, I do.
So if any activity is going on that land, you will be aware of it, true or false? I didn't hear your response, witness.
I said true.
So let's say, for instance, an activity that takes months, you will be aware of it, true or false? Did you in 2016 eject the claimant from the land?
Yes, I did.
When was the claimant ejected from the land? Is it when he cleared the land or when he finished setting up the factory?
Well, when he cleared the land, I informed him that he should not continue because part of the day was not clearing the land, and clearing the land involved something else was going to happen on that land. And he did not inform us that he was going to build a factory there as well.
Hold on. Please, can you hear me?
Yes, Your Lordship.
Yes, I'm very sorry. My network is really unstable. The last thing I heard was that you just witnessed, just like put it
Your Lordship, we can't hear you properly.
to you that you just lied to this honorable court.
Your Lordship.
Hold on, let me try to change my my Can you hear me?
Loud and clear, Your Lordship.
Okay. Let's try to proceed. I said the last thing I heard was that you asked you were putting it to the witness that is lying to this court, right? Please, can you continue from there?
Your Lordship, before we continue, we want to seek the indulgence and the benevolence of this honorable court that because the network has interfered a lot and we've just been able to ask just few questions that the court has taken notice of. If we'd be given the permission to restart this cross-examination, as this witness is very important to us.
Please, you can restart.
I
think that's on me. I would say my network has interfered with the proceedings. So please, it's only fair that I allow you to restart cross-examination.
Thank you very much, Your Lordship. So, witness, can you hear me?
Yes, I can hear you.
Okay, so pardon us. Let us go over the cross-examination again. You just testified before this honorable court that in 1957 you sent a letter of demand to the claimant's father, and in 1999 you sent a letter of demand to the claimant. Is that your testimony?
Yeah, I sent a quick notice to the claimant.
Witness, we have gone over this line of questioning here. Your answer is seeming to
change now.
You
asked me the question again.
The question I'm asking is that when you were being led in chief, you testified that you sent a letter in 1957 to the claimant's father, and in 1999 you sent a letter to the claimant. True or false? Is that what you just said before this court? True or false?
I'm sorry, maybe I couldn't have heard you very well. But now, what I heard, based on what I heard just now, yes, I said to just the claimant.
So you are changing your testimony before this honorable court. I want to just get that.
The network has been so poor. I beg the indulgence of the court.
No witness. We want to find out whether you are changing your testimony, meaning the testimony you made earlier is not correct. True or false?
Yeah, but that was because of I couldn't hear you clearly.
I asked the question twice, but anyway, let's go further. Is your testimony, am I correct to say that you know the land in dispute very well?
Yes, I do.
That is to say, if any activity is going on that land, let's say for months, you would be aware of that activity. True or false?
Yes, true.
So, am I correct to say that you rejected the claimant in 2016?
Yes, I gave him a quit notice.
When did you eject the claimant? Was it when he cleared the land or when he set up the water factory? That's a simple question.
When he set up the water factory, because it was a breach.
Okay. So you waited for him to clear the land, they built foundation, finished building the water factory before you... Witness, let me finish my question.
Go ahead.
When they finished building the water factory before you rejected him, true or false?
False.
Okay. What is your testimony before this honorable court?
That it was upon the foundation being built that I gave him the quit notice because it was a breach. Yeah. So the clearing of the land has nothing to do with it.
So how did you know? That it was a water factory if it was just at the foundation level you saw?
Mainly construct the building itself. For him to bring up the foundation on the land itself is a breach. And then there were rumors of it from the construction members, people working there, that I asked them what was going on here. They said that they're about to build the foundation for a factory. So that was how I gave him the quit notice. Thank you.
Can you hear me?
Yes, I can.
Witness, can you hear me?
Go ahead.
Are you trying to say that your written statement or not is incorrect and not true?
My written statement or not is true.
Okay. Will the leave of counsel seek the leave of this honorable court to read paragraph 18 of the witness statement on oath?
Objection, my lord.
Your Lordship, counsel is objecting.
Are you waiting for me?
Your Lordship, counsel just objected, so I was waiting to take the leading of the court first.
Yes, sir, I'm waiting for you.
Objected, Ms. Chima.
Yes, sir. My lord, these questions are reading all over and over again that my learned friend is trying to do is taking up the time of the court. Since the witness has already deposited on oath and the writing is there is no need for him to keep on reading and reading all over again.
No,
Most
allow
obliged,
him
my
read
lord.
his further questions might emanate from the paragraphs that he seeks to read to the witness. All right, so allow him.
As the court pleases.
The court pleases.
So, witness, you just testified that you stopped him before he set up the water factory. Now, I want to go to paragraph 18 of your written statement on oath and read it to the hearing of this honorable court to show your veracity and your character as a witness. Paragraph 18 reads, Agu ignored my humble request and went on building the water factory. Is that still your testimony before this honorable court?
Unless it was the network giving you issues. I remember saying that I gave him a quit notice. I remember saying that I gave him a quit notice earlier, unless you didn't hear that.
I am asking you when you rejected the claimant. Was it when he was clearing the land or when he finished building the water factory? Which one? Which one?
Not when he finished. I requested that he stop it upon the foundation, and when he continued, I gave him a quit notice.
And your written statement on oath is contradictory everything you have said before this honorable court. Because your written statement on oath.
Ochojila, I'm not sure these are questions, and moreover, you're out of time. I'm not sure these are questions. If you wish to address these issues, you can address them during an address stage. All right. I think you're out of time. I'd allowed you some more time because my poor network actually interrupted proceedings. So that was why I actually gave you more time to try to ask further questions. But now I see that you're out of time and we can't continue with your cross-examination.
As the court pleases.
As the court pleases. Most obliged, my lord. My
because
lord.
I understand that the defendant is equally calling 4 witnesses, right?
Yes, my lord.
All right, so the 5 minutes rule equally apply. So please, Ms. Chima, do you have any re-examination?
No, my lord.
All right. The witness is discharged.
My lord, we stick to call another witness.
Yes, please call your second witness.
Witness, please take the witness box. Witness, please tell this honorable court your name, address, and occupation.
My name is Mr. Osake Orake. I live at the family residence of... I live at the Orake family residence at... Can you hear me?
We can hear you. Go on.
Okay. My name is Mr. Osake Orake. I live at the family residence at Uteli Family District, at Naratuga District, Uteli North, Delta State.
What is your occupation?
I am a farmer.
On 24th day of August 2024, you made a written deposition on oath in this court. Is that correct?
Yes.
If you see this written deposition, will you be able to recognize it?
Yes, I will.
What do you want this honorable court to do with the written deposition?
I want this honorable court to adopt this written deposition on oath as my evidence in this trial.
My lord, that will be all for this witness.
All right. Any cross-examination?
Very well, Your Lordship. Witness, welcome to court. Witness, can you tell this honorable court your relationship to the defendant?
I am the brother to the defendant.
I want you to repeat your submission before this honorable court again. Witness.
Sorry, I can't hear you.
You just testified that you are the brother to the defendant, true or false?
Sorry, my network is bad. I'm so sorry. I'm the cousin to the defendant.
Your Lordship, counsel just wants to find out whether Your Lordship, counsel just wants to find out whether the earlier testimony made by the witness is in the record of this honorable court.
The honorable court is taking note and is considering the demeanor of the witnesses. Just proceed with your questions. Of course, you would have the opportunity to address these points at address stage.
Thank you very much, Your Lordship. Do you know the land in dispute?
Yes, I do.
Good. So, as in your own knowledge, who is the owner of the land in dispute?
Sorry?
Who is the owner of the land in dispute?
The land in dispute is a family land.
Okay. So is the land in dispute, was it purchased by the defendant or was it inherited by the defendant from his father?
It was not purchased by the defendant. It is
was
a
it
family
inherited by, how did the defendant come into possession or ownership of the land in dispute? Was it his father's land or did he buy the land for his whole family?
It was neither his father's land nor did they buy it from the family. It is the family land of the Orake family.
So before the defendants came into ownership of the land, who was the previous owner of the land?
The land in question is the Orake family land.
So is the land in dispute held by the defendant and his siblings or by extended family members?
Counsel, please, can you repeat your question? I didn't get that.
The land, will I be correct to say that the land in dispute is held and owned by the defendant and his siblings?
The land is collectively owned by the Orake family.
The family is too broad, so I want us to narrow it. The land in dispute is just a yes or no question. The land in dispute is being owned and managed by the defendant and his siblings, yes or no?
The land is the family land of the Orake family.
So you are saying no to the question or you are saying yes to the question?
I'm saying that the land is a family land of the Orake family.
Mr. Orake, the question is a yes or no. It requires a yes or no answer. It's a direct question. It says, he asked whether the land in dispute is being managed by, if I heard him correctly, the defendants and the family members. Is that what you asked, Mr. Chojila?
Yes, Your Lordship. I'm asking whether the land is being owned and managed by the defendant and his siblings, yes or no?
Yes, it is.
Okay.
Just for emphasis sake, are you a sibling to the defendant?
Sorry, what did you say?
Are you a sibling to the defendant?
Yeah, go back to this case. I like yeah.
I'm a principal member of the family.
Are you a sibling? Are you the
I am not
defendant's brother?
a sibling. I am not a sibling to the defendant.
So going by your earlier testimony, you do not have ownership rights to the land, true or false?
Objection, my lord.
Ms. Chima, what's your objection?
My lord, the questions he's asking are irrelevant, my lord, and it's taking up time.
No, I consider them to be relevant. Don't. It's not for you to determine whether it's taking my time. It's my time. Allow me to decide if it's taking my time.
As
Okay.
God pleases. As God pleases.
Witness, answer the question.
Sorry, can you please repeat the question?
Are you a sibling to the defendant?
I am a cousin to the defendant.
So going by your earlier testimony, you do not have any ownership rights to the land, true or false?
True.
So going by that, the entirety of your written statement on oath is false because you said you gave consent to the defendant to enter into the customary tenancy agreement, and also where you stated that you gave consent to the defendant to eject the claimant from the land. Meaning,
I'm a principal member of the family. The land is managed by the.
the question is simple. The question is simple. You say you don't have ownership rights to the land. That's gotten. So I'm now saying, if you don't have ownership rights to the land, in what capacity did you give consent for those actions you mentioned in the written statement on oath?
In the capacity of a principal member of the family.
Without having ownership rights to the land. Your Lordship, that will be all for the witness.
All right, any re-examination?
Yes, my lord.
Okay, please proceed.
Witness, you said that you are the cousin to the defendant, right?
Yes.
And a principal member of the family.
Yes.
Your Lordship, there's no objection, Your Lordship.
Ms. Chima, I'm not sure there's any ambiguity. She was quite clear with respect to her responses to those questions.
Most obliged, Your Lordship.
Unless there's somewhere you're heading that we don't know.
Okay, my lord.
Yes. So
No,
do you want to call your? All right, thank you. Witness is discharged. Do you want to call your next witness?
Yes, my lord.
All right.
Witness, please tell this honorable court your name, address, and occupation.
My name is Mr. Francis Akpan. I stay at number 20, Distiller Street, Nagatuta District, Ughelli North of Delta State. And I'm a businessman by profession.
On the 24th day of August 2024, you made a written deposition on oath in this court. Is that correct?
Yes, I did.
What do you want this honorable court to do with this written deposition?
I want the honorable court to adopt my written deposition on oath made on the 24th as my part of my evidence in this case.
That will be all, my lord.
All right. Any cross-examination?
Very well, Your Lordship. Witness, welcome to court.
Welcome.
I put it to you that you don't know anything about the land in dispute, true or false?
That is false, counsel.
Okay, so what is the address of the land in dispute?
Plot, I don't know, I bought that land at 2003, so I think I
You
bought
bought the land?
granted, the defendant left the land to me, part of um an adjacent land to me, not the land in dispute. So I think that's why I'm both as a witness in this case.
Okay, so it was not the land in dispute, not a portion of the land in dispute that was leased to you, an adjacent land.
Yeah, an adjacent land, the left side
So
adjacent. Yeah.
meaning you don't have any testimony and any knowledge as to the land in dispute.
I have a little knowledge, and it is deposed in my deposition. So the little I have, that's what I stated in my
Witness,
deposition.
I want you to listen to the question very well and answer directly. The land that you set up your factory is not the land in dispute. True or false?
True, an adjacent land.
So what input do you have in this case if you don't know anything about the land in dispute?
I was there when a dispute arose between the I think the plaintiff, yeah, Mr. Agu, and the defendant as to regarding their said land, this particular land in dispute. So I was called upon by the defendant to give the little I know about the whole dispute about the said land, and which is what I deposed in my deposition.
So you said that are you aware that the defendant has just one family land?
I don't know about their family. I just came as a tenant, and I let they let a
Are you
portion of the
aware
land.
or you are not aware? Are you aware or you are not aware?
I'm not aware about their family land.
So you don't know anything about the defendant's family land? Yes or no?
I know they just left a part of their land to me. I don't know how many portions they have, and I didn't make inquiry about that. I just went to them and they gave me a portion which we bargained and agreed for me to let. Can you hear me?
Mr. Ochojila, seems it's your turn to experience the terrible network. I just wanted us to confirm that it's not coming from my end.
Yeah, it's not coming from your end.
Okay. That's a relief for me.
Am I discharged?
No, you're
No,
not discharged yet.
it's discharged, yes.
Mr. Zakaria, are you there?
So if there is another member of Team Ruby here, let your teammates know that he's out. Okay, he has already got out. If you can use another, that's an alternate network.
I would bear with him because I am also guilty of this challenge, although it's not our fault. But I mean, being a recipient of your patience, your benevolence and patience, I would have to be a bit patient with him. I don't know
Your Lordship,
if sorry, who's that?
Your Lordship is Eni Ochojila.
I'm back. Welcome back.
Yes, Your Lordship. Thank you very much. So, witness, is it your testimony before this honorable court that the land you occupied and the land in dispute are two different lands?
Yeah, I already attest to that. There are two different lands. Mine is just an adjacent land to the land in dispute.
Are you aware that the land in dispute is bearing plot 356, which you just attested to and testified to that is the land you built your factory on top?
Correction, I didn't testify to that or I didn't attest to that. I told you that I couldn't remember the plot number as to the last time I went to the land was 2005 when I was ejected by the defendant. So I couldn't remember. That's what I stated. I don't know if you
Okay, you
understood
just
that.
said something. You said the last time you went to the land was 2000 and what?
2005, 2006 there about when I was ejected by the defendant.
Okay, so you are not sure of the exact date you were ejected.
There about it's over 15 years ago or thereabout, so I can't actually remember, but in between 2005 and 2006.
Okay. Can you remember paragraph 5 of your written statement on oath, where you said that in 2005 you met the claimant and he told you that you built his factory on your land? Can you remember deposing to that witness that written statement on oath?
Yeah, I did that.
Can you remember deposing to the fact that in 2005 you met with the claimant and he told you that you built your water factory on his land?
Yeah, I said that that's what he told me, but I didn't know if that was correct. As to it wasn't my issue. It was him and the defendant, but that's what he told me, and that's what I attested to in my paragraph.
So you don't know. So do you know the claimant's land?
He told me I was building on his land. That's what
Do
he
you
told me. I
know
don't
the
know.
claimant's land? Just answer yes or no. Do you know the claimant's land?
I was told by the defendant that it was the adjacent land to me.
Do you know the claimant's land? I want to know if you know the claimant's land.
Yes, I do. I know the claimant's land.
So can you describe where the claimant's land is? From the land you rented,
by the defendant. Is that the land you're talking about? The one that the
Mr.
defendant.
Joshua, you're out of time. I'm sorry. You're out of time. So,
most of land
any re-examination? Ms. Chima. Miss
My
Chima.
lord, my lord, this
Chima there?
Igbalade, Chima got logged out.
Okay.
But there is no re-examination for this witness, my lord.
All right. Thank you.
Thank
you want
you.
to call your fourth witness?
Yes, my lord. Yes, my lord. We seek the leave of court to call the fourth witness into the witness box.
All right. Please proceed.
Witness, can you tell this honorable court your name?
My name is Mr. Ralph Eze.
Witness, please tell this honorable court what you do for a living and where you live.
I am a laborer and I live in plot 342 Ubono, Itakele District, Ugele North, Delta State.
Witness, you made a written deposition before this court dated 24th August 2024. Is this correct?
Yes.
What would you like the court to do with your written deposition?
I would like this court to adopt this written statement on oath as part of my evidence in this case.
My lord, that will be all for this witness.
All right. Thank you. Cross-examination.
Thank you, Your Lordship. Witness, welcome to court. Can you hear me, witness?
Yes.
Do you know the land in dispute?
I know the land in dispute by virtue of my work on Mr. Kwan's land.
Okay, so you are very conversant with the land in dispute.
No, I am not conversant with the land in dispute. I only happen
to the best of your knowledge, the land you cleared is not the land in dispute, true or false?
True.
So you cannot give testimony if palm tree was cultivated or cut down from the land in dispute. True or false?
On the land that I was hired to clear, I did not cut down any palm tree. So if there's any...
I'm asking about the land in dispute. Did you enter the land in dispute? The land in dispute. Did you enter the land in dispute at any time?
No, I did not.
Did you see anybody entering the land in dispute at any time?
I cannot say.
You cannot say if you saw anybody, okay?
I
How
was
many
not
days
focused
did
on my
it take you
objective.
to
It doesn't
walk?
bother me what happens on the
How
other
many
land.
days did it take you to walk on the land that you cleared? How many days?
I cannot say for certain how many days it took me, but it's clearing of grasses and shrubs. I wasn't cutting down anything, so it didn't take me much time. So at most 5 days or 10, I can't really say.
Okay. So you do not have the knowledge to tell this honorable court whether palm tree was cut in the land in dispute. True or false?
If any palm tree was cut in the land in dispute, I have no idea of it.
Okay, you don't have any knowledge on that.
No.
Thank you very much, witness. That will be all, Your Lordship.
All right. Thank you. Any re-examination?
No, there will be no re-examination for this witness. We humbly apply that this witness be allowed to leave the witness box.
All right. Thank you very much. Witness is discharged. Ms. Bolade, is that all for the... Is that the case of the defendant?
That will be the case of defendant.
All right. Thank you very much. Now, I would assume that you guys are ready for address. Ordinarily, you're to file written addresses. The defendant, being the party that gave evidence last, ought to have filed a written address, and then the claimant will then file its own written address as well upon being served with the defendant's written address, and then the defendant will have rights to file a reply address. But for the purpose of this competition, we will just take oral addresses from counsel, summarizing the evidence, the facts, and the law. All right, because we'll still need to assess you on that as well. So I'm minded to give you 5 minutes to put your thoughts together, based on the evidence that you've just elicited during the trial, or the evidence you've sent and all of that, to put your thoughts together. And of course, the defendant will address me, then the claimant would respond, and the defendant will have a right of reply. I mean, subject to whatever my learned brothers would say, and then the host. My learned brothers, over to you. Any objection, any contribution before they proceed? Before we proceed on a short break for address and reconvene for address.
Okay. Your learned brother has responded. Okay.
Okay.
2 of them. It's remaining 1. Justice Mary.
Okay, let's just take it that she's in alignment with us as well. So we'll proceed on a 5 minute break for council to put their thoughts together and then address us.
So, Your Lordship, my brothers on the bench, I think the 5 minutes is up.
All right. Mr. Ochojila and Ms. Bolade, are you both ready? Ms. Bolade,
Yes, Your Lordship.
are you ready?
Yes, Your Lordship.
Okay. So please proceed.
My Lord, this is defendant's final written address dated 4th September 2024. My Lord, we humbly seek to adopt this final written address as our argument in urging this honorable court to enter judgment in favor of the defendants. My Lord, we seek your permission to adumbrate on the issues in the final written address of the defendants. My Lord, by way of adumbration, defendant has
Okay, hold on before you proceed. All right. I just want to I just want you to be calm, all right? And I also want to assist both parties as well. All right. This is a very crucial part of this competition, and I would encourage both parties to take it very seriously and be on their A game, because this is a very crucial part of the competition, and it can swing the pendulum one way or the other. All right. So if you need 30 seconds to catch your breath, I'm happy to give you 30 seconds to catch your breath. And then if you need to, get up and move around, I mean, that's fine. Just want you to be calm and take this part very, very seriously and be very careful. This applies to both the defendants and the claimants. All right. So, Ms. Bolade,
Yes, my Lord.
you want to catch your breath?
Yes, my Lord.
Okay, I'll give you 30 seconds to do that.
Most obliged, my Lord.
Thank you.
My Lord, I'm ready to go on.
All right. So please proceed.
My Lord, this is the defendant's final written address, dated 4th September 2024. My Lord, we humbly seek to adopt this final written address as our argument in urging this honorable court to enter judgment in favor of the defendants. My Lord, we seek your kind permission to adumbrate on the issue, on this issue in the final written address of the defendants. My Lord, by way of adumbration, the defendant has formulated a sole issue for determination. Whether from the totality of the evidence led at trial, the claimant has proved his case as required by law to be entitled to judgment. My Lord, from this claim, the defendant seeks the following relief from this noble court. First, an order that the fundamental breach of the condition of the agreement by the claimant entitles the defendant to repudiate the contract. 2, an order that the customary tenancy between Orake family and Mr. Ako, who is deceased, now Mr. Agu, has been terminated due to such breach. 3, an order that Mr. Agu no longer owns possessory rights of the property. 4, an order for the claimant to pay to the defendant a sum of 310,000 naira. 310,000 naira as rent owned between 1954 to 2016 at the rate of 5,000 naira yearly. 5, an order that the abandonment of the land by claimants for 3 years without entrusting it to another brings the said tenancy to an end. 6, an award of 150,000 naira as general damages. brief fact of the case. Subject matter of this action is the land which belongs to Orake family. Was given a customary tenancy to Mr. Aku on the condition that palm trees only should be cultivated. His son, Mr. Agu, took over from Mr. Aku after his death. The Orake family invested in the land on the promise of 20% payment from the annual harvest. Mr. Agu fulfilled this promise to pay 20% to the Orake family. Mr. Agu left the country for medical treatments and left the farm to fall into disrepair. Mr. Agu, upon his return, set up a pure water factory on his land. Arguments. Whether from the totality of the evidence led at trial, the claimant has proved his case as required by law to be entitled to judgment. My lord, it is the Supreme Court, as mentioned in the case of Abioye and Yakubu, that the legal nature of a holding under customary tenancy is that the holding of the customary tenant is not a gift, nor a loan, nor a land given for an indefinite term, for a definite term which differentiates him from a leasee. The customary tenancy is a grant upon terms and conditions agreed with the owners, and provided that it keeps to the conditions of the grant and payment of tribute, customary tenants can keep and enjoy possession of his holding from years to year in perpetuity. But no matter how long he is on the land, he does not and cannot acquire ownership. He is liable to incur forfeiture and lose his tenancy on breach of the terms and conditions. Other case in point, Akiloya Itola 1968. My lord, this Court of Appeal also heard in case of Ogunoke and Ogunoke that the presentation of kola nuts is a customary practice in Igbo land, which connotes a symbol of peace, friendship, and mutual recognition of rights. It is a tradition that has been passed down from generation to generation, and its significance cannot be ignored in resolving land disputes. My lord, kola nut in Ugeli North community is used to signify and seal friendly relations between parties as a symbol of unity, peace, and love. My lord, the Supreme Court also pointed out in Abioye Yakubu, stated previously, Supra, that although within the terms of the customary tenant has the appearance of an owner, he can only use the land on the terms and conditions he agreed with the customary landlord. Not only was his interest divisible by his behavior, but also his possession, no matter how long, can never ripen to ownership. Akiloye and Eyilola, Supra as well. My lord, the main object of paying customary tribute or rendering the traditional services is the acknowledgement that the stranger occupier is not and does not claim as owner. It is an assurance that of the continued acknowledgement of the title of the grantor. It follows then that a refusal or seizure of either would imply either a challenge to the grantor's title and would therefore apply as a forfeiture. My lord, the Supreme Court of Nigeria, with full endorsement, considered the full meaning of abandonment by recognizing definition in the Black Law Dictionary as the surrender, relinquishment, disclaimer, or cessation of property or of rights. The giving up of a thing, absolutely, without reference to any particular person or purpose, as vacating property with the intention of not returning. My lord, the claimant did not tender any of the front-loaded evidence before the court today. There is also no evidence that any palm tree was cut down before the court. My lord, the fourth claimant's witness is a mere member of the family and has no knowledge of the details as it is a family land. My lord, the land is managed by the family head and principal members who make all important decisions. My lord, the land was given with their consent. My lord, the first plaintiff heard all the details he presumes to know from his father's dying bed. He cannot be said to have sufficient knowledge of the land in question, as there is a 35-year gap, as opposed to Mr. Orake Osake, who was a party to the contract. He also mentioned during cross-examination that the second witness, who is Chief Kalu Ugochukwu, is not a party to the contract. So how can we believe such a person to have full facts of the case? My lord, Mr. Akpan Francis, who deposed being given the same land in the front-loaded document of the plaintiff, was not called as a witness. The witness deposition also bears a different name from his lease agreement. My lord, the plaintiff abandoned the rest in question on a supposed medical leave. However, the plaintiff has presented the court today with a medical certificate bearing a different name from his. Agu Francis. My lord, the claimant has not only left the country, but also abandoned the rest given by my client, the defendant, allowing the said land to fall into a state of disrepair. This was proved by presenting the photograph and the certificate, of which the claimant did not raise any opposition to it. My lord, the plaintiff neither handed over the land to a professional to manage, nor did he inform the defendant of his proposed trip, nor did he even attempt to contact the defendant during those years of his absence. My lord, the plaintiff has shown clear intention to abandon the land, and he has also failed to respond to the letters written by the defendant to him about his whereabouts. My lord, the land given to the plaintiff is vast, and is expected of him to take good care of it as an implied condition of the grant. My lord, the rest in this case remains a family property, and the interests of the numerous members of the family should be protected. My lord, the Supreme Court has held in the case of Adeleke and Oduwole that the landlord's rights address the landlord's right to claim damages for the loss resulting from the tenant's premature departure. My lord, also in Olowo and Oguyemi, the court inferred abandonment from prolonged absence. My lord, in UBA and OAME, the court held that abandonment constitutes repudiation of contract. My lord, based on the above arguments, the claimant cannot be said to prove his case as required by law to entitle him to judgment. My lord, based on this argument, we urge your lordship to enter judgment in favor of the defendant. May it please your lordship.
Thank you very much, Ms. Bolade. Mr. Ochojila.
Very well, your lordship. Your lordship, the matter before this honorable court pertains to a customary tenancy between the defendant and the claimant. The substratum of this case, in the humble view of counsel, is that it relies on three key issues of determination. One, whether the claimant paid any tributes to the defendant. Two, whether the claimant breached the conditions of the customary tenancy. And three, whether a notice of owner's intention to recover possession terminates a customary tenancy. Your lordship, to the first issue, which is whether the claimant paid any tribute to the defendant, your lordship, counsel answers in the affirmative. Your lordship, in the case of Akin Bade and Babatunde 2018, 7 Nigerian Weekly Law Report, part 1618, the Supreme Court held that the payment of tribute is a key element when it comes to customary tenancy. Your lordship, under Nigerian customary law, tribute is usually given with farm produce. Just for example, kola nut. In the instant case, the claimants through CW1 and CW2 gave evidence before this honorable court that before taking possession of the land in dispute, kola nut was given to the defendants and his family. Your lordship, even the court in the case of Udensi and Mogobo, 1976 EC 6 ECS law report, part 354, the court held that kola nut is a valid tribute. Going further, your lordship, to issue 2. Issue 2 is very important in this matter. Issue 2 is that whether the claimant breached the condition of the customary tenancy. Your lordship, to this issue, counsel answers in the negative. Your lordship, although the defendant, through an unpleasant and unusual substitute, alleged that the claimant owes him unpaid rent, from a careful perusal of the statement of defense, it is clear that no such stipulation or agreement was made at the time the customary tenancy was entered into. Your lordship, on the other hand, the claimant gave evidence through CW2 and CW1 that no such agreement at the time the customary tenancy was entered into in 1954 were there any stipulation as to the payment of rent. Going further, the defendant, neither through himself, DW2, DW3, or DW4, did not give any evidence to the fact that at 1954, when the customary tenancy was entered into, an agreement was made by the claimant's father to pay rent. Your lordship, going by this, counsel submits humbly before this honorable court that the failure of the claimant to pay a rent that does not exist is not a breach to the conditions of the customary tenancy. Now, your lordship, it must be equally admitted that under customary tenancy, where the land is used for a purpose other than that which was agreed, it is a breach. But this is just a general rule, and as to all general rules, It is not without its exception. The court was swift in the locus classicus of Abioye and Yakubu in 1991, All Nigerian Law Report Part 1, when the court held that a land under customary tenancy can be used for the purpose other than which was agreed with the consent of the overlords, in this case, the defendant. Now it begs the question, was there consent? Your Lordship, to answer this question, Council will extrapolate two key doctrines of law. One, the doctrine of estoppel. Two, the doctrine of laches. As regards the doctrine of estoppel, Your Lordship, the land in question was given by the defendant to the claimant's father to be used for the cultivation of palm tree. Quite okay. But that same land was given to Akpan Francis, and the defendant gave consent that that land can be used to set up a factory. Your Lordship, going by this, the claimant who acted on the implied consent that that land can be used to set up a factory, which he followed suit, and going by the doctrine of estoppel, the defendant will be stopped from claiming that that consent was not given. Now, going further, Your Lordship, as regards the doctrine of laches, it was clear that the defendant is living in the adjoining land to the land in dispute. That is to say, every activity that goes on the land, he is aware. And during the cross-examination, he alluded to the fact that he is aware, very aware, much aware of the facts and activities that go on in the premises. So when the claimant called people to clear the land, he was aware. When they started building the land, he was aware. Till the land was finished, he was aware, but he did not do anything. And the court, in the case of Ayorinde and Kofoju, 2022, 12 Nigeria Weekly Report, part 1843, page 43, the court says that when the claimant has expended money on the land and the defendant stood still and did not do anything until that process was finished, it will be too late in the day for the defendant to wake up and seek redress. Conclusively, Your Lordship, Counsel submits before this honorable court that in no way did the claimant breach the conditions of the customary tenancy, and we humbly pray that this honorable court oppose this submission. Now to issue 3, which is very salient, sacrosanct, and fundamental, which is whether a notice of intention, of owner's intention to recover possession, can terminate a customary tenancy. Your Lordship, to this counsel answers in the negative. My Lord, it is pertinent to state that customary tenancy is peculiar to customary law, and against the postulation just made by the counsel in her closing statement that this is a contract. It is not a contract. It is a customary tenancy, and customary tenancy is peculiar to Nigerian customary law with no equivalent under the English law. Flowing from this, the court has severally held that customary tenancy can only be forfeited and determined by an order for forfeiture. The court in the case of Olukunlade and Samuel, 2011, 7 Nigeria Weekly Report, part 1618, page 366, the Supreme Court held that the proper claim for an erring customary tenant is forfeiture. Unfortunately, in the instant case before this honorable court, the claimant did not approach the court for an order for forfeiture, but went to purportedly institute a notice that is under the English law, knowing fully well that customary tenancy is not governed by English law. Your Lordship, counsel will humbly refer this honorable court to the locus classicus of Abioye and Yakubu earlier cited, where the court held that customary tenancy is to be held ad infinitum until forfeited. The court view is alleged forfeiture is not even
So it's this Ochijola. It's out. Please, if there's any other member of his team, let him know that if there's another device that he can use to come back in.
Hello, can you hear me?
Yes, we can hear you.
Is Mr. Zakaria not there?
No, he's not.
I see.
Oh, and I don't, if there's another member of his team that is still here and you're in the same place, just log in. Allow him log in with your device. Sure, he'll be trying to log in.
You see how many minutes more?
2 minutes, 26 seconds.
2 minutes, 26 seconds. I can see.
It was paused.
Mm.
Oh. Ochijola, we're actually waiting for you. I think we can see you now. Yes, we're actually waiting for you.
Okay, thank you very much. Sorry, my net, somebody called me, so the network got disconnected.
I just, you can see the time on the screen. It was paused. You just have 2 minutes, 26 seconds.
Thank you very much. Thank you very much.
Subject to, sorry, your lordship, please.
Yes, please, Mr. Ochojila, you can please continue from where you stopped, if you would recall.
Your Lordship, Council wants to just confirm where the court stopped last heard me.
What's the name of the case? Because at some point I was having some network issues. There was a case you cited, and you were trying to amplify the law in that case and all of that. I think that was where I lost you.
Okay, I think let me just pick up from where I think you last heard. Your Lordship, in the case of Abioye and Yakubu earlier,
that's right. That's the case. Yeah.
The court held that customary tenancy is to be held ad infinitum until when forfeited by the court. The court went further in that case to state that even when misbehavior is alleged, forfeiture is not automatic, as is a proceeding that must be brought before court in the appropriate proceeding. Your Lordship, in this case, the notice to quit and the notice of owner's intention to recover possession is not the adequate proceeding, and thus cannot terminate the customary tenancy. It's a humble submission of counsel that the customary tenancy held by the claimant is still subsisting. Your Lordship, counsel would like to just pay and humbly draw the attention of this honorable court's mind to the testimony given by the witnesses. The DW3 and DW4 totally did not have any knowledge as to the land in dispute. Thus, their testimony and total oral evidence is of no relevance, and it is strikes law that the gamut and the hallmark of evidence is relevance. Also, Your Lordship, DW1 and DW2 in their demeanor, in their tenor, in their actions, and in their words were contradicting themselves both in the oral submission and in their written statement on oath. And the Supreme Court in the case of Zikaria and Mohammed 2018 Law Pavilion Electronic Law Report 42349 said that when a witness gives two contradictions on material facts, the witness is to be treated as untruthful, unreliable, and regarded as a perjurer who does not deserve to be credited with honor. Your Lordship, it's on this basis that counsel humbly rests his case and pray that this honorable court upholds the submission of the counsel on all issues and grants the relief sought by the claimant. I so humbly submit.
Thank you very much, Mr. Chojila. Ms. Bolade.
Yes, Your Lordship.
Yes, you have a reply.
Yes, Your Lordship.
Okay, please proceed.
Your Lordship, the claimant counsel, as mentioned, the third issue of claimant counsel was premised on the fact that the notice of owner's intention to occupy possession is not a suitable means of termination of customary tenancy. Your Lordship, I think it is, would I say, commonsensical to legal practitioners that the owner's intention to occupy possession does not terminate the landlord-tenant relationship. Instead, it is the notice to quit which terminates the landlord-tenant possession relationship and then changes the landlord to the owner, which is why a owner's intention to occupy possession is then filed for the recovery of property. My Lord, as regards the defendant's witness 2, 3, and 4, as regards their relevance, which was raised by my learned counsel, facts, it's tried law that under the Evidence Act that facts which are otherwise not relevant, but by virtue of the circumstances of the case become relevant. In this situation, it is the claimant himself who has raised the issue of the fact that the land that was given to Mr. Akman was the same land that was given to Mr. Agu and later Mr. Aku and subsequently Mr. Agu. Therefore, I think it's commonsensical to assume that the said Mr. Akman, who was mentioned, he should be allowed to come to tell the Honorable Court which land was given to him by the Orake Osake family, and as well as the person who cleared the land, because it is the council himself who had made mention of the plantations being cleared in order to allow the land to be given to Akman. So on this basis, the defendants rest his claim not on forfeiture, but on abandonment, that the abandonment of the claimant for 3 years is what has resulted in bringing the said tenancy to an end. And this he has done by making it legal, by taking legal steps through filing the notice to quit, as well as the owner's intention to recover possession. That will be all for the defendants, my lord. May it please the court.
Thank you very much, Ms. Bolade. So it's been very interesting and enlightening session. I would say I am deeply impressed with your submissions, your performances. All right. Considering the fact that, I mean, are you guys lawyers or law students? I need to confirm before I will be commending you guys. I know the level of commendation I will give to you. Mr. Uchojila, are you a lawyer?
Not at all, Your Lordship.
Are you a pastor? Because we were speaking like a pastor a couple of minutes ago. If you open a ministry, you will get a lot of followers. Well
Probably
done.
after law school, we'll consider that.
Oh, I see. I see you are considering it. Okay. Miss Bolade,
Yes, Your Lordship.
are you a lawyer?
No,
Saw the
well,
way you were making submissions. I mean, I'm sure that if you guys meet me in court, I'm sure that you will floor me. I was scared for a moment. Even Mr. Zakaria and Miss Chima as well. You guys have done really well. Like I said, I'm very, very impressed with your performances. I want you all to keep it up. Like I said at the beginning of this competition, it's a learning process, both for us on this side and for you guys as well. And we've come to the end of the entire proceedings, because after final addresses, the court would adjourn for judgments. But in this case, I will not be reading out any judgment, because the judgment you get would be the result of the competition. All right. But I would like to point out certain things so that at least you learn again from maybe the little mistakes you've made, and also from where you've really done well. We point out those aspects of it. Like I said earlier, by and large, I'm very satisfied with your performances, and of course, there must be a winner. If you ask me to decide, I would say both parties are already winners. Just distribute the money, whatever you're going to give to them, just share it and say, everybody take your own and go. All right. But of course, somebody has to emerge victorious. So I'll just, with respect to the proceedings, I'll just make certain comments, and then I'll yield the floor to my co-judges to also make the comments, whatever comments they have, with respect to how you both have conducted proceedings, and the things that you missed out and the things that you really did well. All right. So I would start with the claimant's examination in chief. All right. The claimant's first witness, in fact, and this was something that continued throughout it applied to all of the witnesses that the claimant called. Now I realized that after the Mr. Zakaria asked questions to ensure that the witnesses adopt their witness statement on oath, he still gave the opportunity to the witnesses to now give oral evidence. They started to rehash everything that they already have in their witness statement on oaths. All right, that's wrong. In as far as the front loading process is concerned now, examination in chief is restricted to the adoption of the witness statement on oath. The witness will not be allowed to say any other thing. After the witness adopts the witness statement on oath, that is examination in chief. The witness should not be making more statements to rehash whatever he has said in his witness statement on oath, or give further evidence. The witness statement on oath is the evidence in chief. All the counsel needs to do is to get the witness to adopt that witness statement on oath, and then cross-examination will follow. All right. And then the claimant also made a very, very serious um, mistake. I'll just say that. The claimant, of course, pleaded a lot of documents and front-loaded these documents, but the claimant did not tender these documents through the witnesses. All right. The first witness, Mr. Agu, you were supposed to tender some documents through that witness after adopting the witness statement on oath. All right. The next would be to refer the witness to the paragraphs in the witness statement on oath where he made mention of certain documents and get to tender those documents. Now you've presented your case and you did not bother to tender those documents. Of course, it will be taken that you've abandoned those documents, and that can be fatal to your case. All right. So equally, the third witness that ought to also tender another vital document that the claimant relies on, the lease document, was not called. All right. So these are issues that you need to. I mean, going forward, of course, I'm sure you should not make that kind of mistake as practicing lawyers. But I just thought to point that out. With respect to the witness giving further oral evidence after adopting the witness statement on oath, applied to the second witness, Kalu and Mr. Okowa as well. All right. I'm generally satisfied with cross-examination of the defendant's counsel with respect to the witnesses. Then, again, I must commend the defendant's counsel, Ms. Chima, with the way she conducted the examination in chief. All right. You would see the way she examined the witnesses and ensured that she tendered all documents that the defendant needs to rely on. All right. So well done. Again, I'm generally satisfied with the cross-examination of claimant's counsel. Again, I just thought to also point out with respect to the addresses of counsel. Again, kudos to both counsel. You did well. I'm very, very satisfied. Considering your level, I would say that you both really did well. But I just wanted to point out that I must give special commendation to the claimant's counsel, Mr. Ochojila. You'll see the way he was trying, because address is not just about you coming to say what the law is. Of course, the judge already knows what the law is. All right, he already knows what the law is. It's not about you coming to regurgitate the laws and try to. Of course, it's an opportunity for you to show your eloquence, but again, your ability to marry the facts to the law, your ability to marry the evidence to the facts and the law. Because during trial, you of course you elicited some you tendered some evidence, you elicited some vital evidence from the witnesses during cross-examination. That's the aim of cross-examination. All right, you must have elicited evidence that you intend to rely on to discredit the case of your adversary and support your own case. So during your address, you must find a way to marry the law to the evidence that you've elicited. And I could see, I saw Otrojila doing that repeatedly, referring the court to the witness testimony of the witnesses, saying that this witness testified during trial that this happened, and the witness failed to testify that this happened and all of that. All right. So he was constantly referring the court to the witnesses, testimony of the witnesses, and trying to marry the testimonies to the facts and the law. That was something that Ms. Bolade did not do. She made very fine arguments, excellent, but she did not marry the evidence to the argument, tie them together, and show the court why certain witnesses should not be believed, and why the testimonies of some witnesses should be believed over the testimonies of other witnesses. All right, I just thought to point out these issues. Generally, like I said, I commend all of you. You did very well, and that's my 2 cents with respect to the proceedings so far. I would now defer to my learned brothers to, give their observations and make their comments.
Hello. Please, am I audible?
Yes, I can hear you loud and clear.
Okay, sure. Thank you very much, your Justice Chimezi, presiding judge today. That was extremely amazing. I've enjoyed your facilitation as well. And then also to Barrister Ruth, amazing session we've had here. Quite pulsating, I must say, as both parties have shown indeed and demonstrated immense legal acumen in this current matter before this honorable court. I wouldn't want to go into the legalistic issues that has been presented before us, as our learned judge here, Chimezie, has spoken on the procedural matters that have been before us. But I would be speaking more on oral argument and oral presentation. I must first and foremost commend both counsel or learned counsel for Team Ruby and Pearl for showcase of immense and great talent in terms of their advocacy. But I also observed I observed that there was so much passion in the delivery, to the point that sometimes councils would go overboard in terms of I was expecting that you treat it, even though it's virtual, you treat it as though you are in court, and be mindful of your mannerisms, be mindful of your expression. There were so many extra movements that were not really necessary. That in court, the court would have in-person courts, maybe the judges would have attributed such mannerisms to mean something else. And so I would want us to be mindful of this moving forward as we journey in our legal career. But I must also say that I was very impressed with is it Bolade Hannah? Amazing lady, awesome. You did extremely well. And there were points when you were so dismissive, and it was like, okay, I've caught you right now. Okay, go. No more questions. And I was really, really impressed with the fact that you didn't want to proceed when you caught them. And then amazing presentation by Nicholas Ochojila. That was awesome presentation once again. I was particularly impressed with how you were able to, while on your feet, it means that you really had you internalized the fact of the matter, and even your presentation, and even more on the legal aspect, how, like his learned judge Chimeze said, you were able to marry the written submissions with the oral submissions. You really proved to be on top of the issues, and I must commend you for this. And let's get connected on LinkedIn. You are so amazing, and I would want to engage you even further. So thank you very much. These are some observations that I made, and I really wish you all the best. You were all amazing. You were all extremely great. I can't wait to meet you guys again on my next visit to Nigeria. I think towards the end of the year. We're supposed to be in G. Elias. I would have been able to meet his learned judge, but hopefully I will be able to meet you all in person. Thank you very much.
Thank you very much, my learned brother Alfred. That's very apt. My learned brother, Mr. Okocha, are you still there?
Yes, thank you very much, my little brother. Yeah, I must, I will just lean on what the presiding judge has said, and also my little brother, Judge Alfred. I must commend the Mutas. I would say it was really an amazing session. Starting with the facts put together by Ruth. I like the tempo in the fact made it look like perhaps it could swing both ways. And one we appreciate it from the angle where they try to say, okay, fine, would that it need too much to start bringing in issue of statutory documents on notice to quit? Does it really apply to customary tenancy? There were those questions that could not come up as to what's really the mode of trying to get them out. And then to start it from the beginning, I would just want to quickly start with advice because my little brother, George Timothy, has already like given all the admonitions. I just want to add that it's very important that before you start out in something like this, you have like a trial plan. You know what you want to really achieve. If you're going to call, because if you look at the facts, somebody wants, so somebody claims to have proprietary interest in the land, and so because he has proprietary interest in the land, he wants to evict the tenant. So and you can only do that through a forfeiture according to some case law. So how many witnesses do you ordinarily require to do that? So there's that question to avoid people giving different testimonies because some of may have happened during the session. And do you really need four? That's the big question. And on the other side, you come back after your ailment and then you discover that things have gone awry. Do you also need four witnesses as well? So you need to also understand that we are judges here, we are observing everything. We're like, do you really need four? So that should, I mean, as a lawyer, do you think that you cannot have put that case better by just using two witnesses, for example? I mean, that's just a thought. You get, and also on trial plan, you want to ask yourself questions like, I mean, say for the suo motu issue raised by my learning brother, the issue that had come via a perennial objection, if one wants to really interrogate it further, as a defendant / counter claimant, did you really have to bring that perennial objection, knowing full well that you actually have an interest to get the defendant, the claimant, defendant to counter claim out of your property? Because of the underlying principle that if that counterclaim, let's say your PO survives, then that would ordinarily mean that you have to go and file a fresh action anyway. So you want to be sure on your case management strategy, and then if I may add, I think the part on the final written addresses was really commendable. Really commendable. I must commend Ochodila. I like the fact that this might be reiterating now, but I like the fact that you actually spoke to the witness statement, the evidence led so far, and you carried me along. I'm speaking for myself. You carried me along as to, okay, fine, this happened, these were contradictions, and and that is very commendable. So and also it seemed like you had a portfolio of laws in your bosom. You just had a lot of case laws to supply us, and that's encouraging. And also to Bolade to you were very vocal about your position. You were very clear. This is your own position, and and what I observed is that you both were really like a bit sort of updated, on the legal procedure and legal procedure, substantive law as well. So and then that, I must commend you guys as well. If not, I mean, there'll be a lot of, I'm sure there'll be a lot of interjections from my learning brother saying, no, I don't think that's the right thing to do. But you guys allowed us to follow through on the process. So thank you, and please, the sky is just the starting point. Please, more and more of the same. I'm sure this will boost your confidence. And yes, like my little brother said, you both are winners. And please, continue pushing yourself further. All right, thank you very much.
Thank you to my learned brother for the very warm comments. Ruth, I think we'll yield the floor to you now because we've done our part here and our watch has ended. All right, so
Oh,
hand over to you. right?
Thank you to my awesome judges. Thank you. Like I was telling my colleague here that first I did not believe that this would stay this long. Okay, yeah, I did not believe that this would stay this long, and I just I can't but appreciate you all for staying. Thank you, Eli, for staying. I know that you have a professional exam. I'm really so grateful that you stayed. Thank you, Ugo, Justice Ugo. Thank you, Justice Eli. And then Justice Mary, she just had to leave because her device was, that's her battery was running low. But she was here till the two parties were giving their closing statements. And then to my awesome presiding judge, I sent you a WhatsApp message. I don't know if you're considering career in the bench. I'll be the money. We need to secure the bag.
I will not get enough money from the earlier as a law student. I had considered that I wanted to be a judge because of how well judges are respected and how you are able to develop the jurisprudence
Mm.
by your very erudite rulings and judgments, and then your name will always be out there. But once I became a legal practitioner and I started seeing small money, I said, no, I want to continue in this line.
Yeah, the bag.
Mm,
Okay. But
mm.
I think we need intellectuals too at the
Uh,
bench. You know,
Ugochukwu can go to the bench. You will be useful there.
okay, Ugochukwu also, I'm sure I wouldn't put this thought process far from him too. He also looks like someone that wants to secure the bag. Ugo, am I speaking your mind? Okay. Oh, see now, he also wants to say, if everybody is securing the bag, who will secure our legal system now? Eli, what do you think? Do you also want to secure the bag? Eh?
I would like to align with my learned.
Okay, it's ladies that you feel don't need the bag. Okay. All right. That aside, I must really commend you all. Thank you. It was really I'm sure beyond the competition that the students learned a lot from. It was not just they learned a lot from it. I learned, and just as you said, we all learned from this because of the inputs by you all. Thank you so much. Thank you so much. And then I must really commend the students. This was really beautiful. That question that Justice Mezier asked at the before he started his closing comments. Are you law students or are you lawyers? That was you all really putting your best foot forward, and we all here, even in the office, are appreciating the quality of the research, the quality of legal knowledge that you have not just gained, but you have practiced through this, from the pleadings that you sent, the arguments, even the preliminary objection, yeah, and now the hearing proper. Usually, last year, this is the first time I'm experiencing a virtual Moot. Last year was a physical event, but a lot of things, both the financing and all that, we had to have a virtual competition this year. But then usually we have something for both the winner and the first runner-up, but we all know how things have been. So we just have one just for the winner. But just to let you know that whoever emerges as the winner, I just want to let both teams know that you all are winners. Let me use the words of my brothers on the bench. Just know that you all are winners and you people did your best. And I'm sure that your legal knowledge has expanded by reason of this competition. And that's actually the primary purpose. The foundation is all about promoting excellent legal education. And we really appreciate that you appreciated that objective and brought in your best towards this competition. So well done to the teams. You would see the results by the time the flyer comes out on social media. And I just want to encourage you, just keep it up. Whether you emerged as I'm using that, this is quoted in quotes, whether you emerged as the winner or not in this, just so that it was a fierce competition on both sides. So I look forward to celebrating your wins in other competitions beyond the HJIUF by reason of the legal knowledge and expertise in moot court trials that you've gotten in this moot. All right, I would just want to call it a day. Thank you for being part of this. I appreciate you all, my awesome brothers in the bench. Thank you. Mezier.
All right. Thank you very much, Ruth. My learned brothers. It's been an interesting session, and it's been a pleasure doing this with you both. I hope we'll do this some other time again. For now, thank you very much, and bye.
All right. Bye. Bye, Tim, Ruby, and Pearl. All the very best. Okay.
Thank you, ma. Bye.
Bye.
Thank you, ma.